Dattilio. Okay, thank you.
Yep.
Morning, P.O. Walker.
P.O. Walker, you can press *6 to unmute.
Can you hear me?
Yes, I can hear you.
Okay.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Zachary Dattilio, 342-478. Today is Tuesday, January 7th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Zachary Dattilio, number 342-478.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Dattilio.
As well as P.O. Walker.
Good morning. This is Parole Officer Walker of the Hartford Parole Office.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony of today's hearing will be taken under oath. Mr. Dattilio and P.O. Walker, please raise your right hands. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes. I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, the state as well as your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review that evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
I do, Miss.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, reporting, P.O. Walker.
You failed to report with your parole officer as directed and scheduled on 9/10/24 and 9/11/24. You are aware of your scheduled report date. On 9/10/24, you contacted your parole officer and requested to report on a 9/11/24. On 9/11/24, you were given ample time to report, specifically from 9 a.m. to 11:30 a.m. and again from 2 p.m. to 4:30 p.m., and you did not make any effort to report. On 9/12/24, you admitted that you knew you were supposed to report and did not. Based on this information, you are in violation of standard parole condition number 1, release direction.
Charge 2, program participation.
You failed to attend the CHR Explore program on 7/15/24, 7/22/24, 7/29/24, and 8/5/24 per the provider. On 8/6/24, you were unsuccessfully discharged from the CHR Explore program due to violation of the attendance rules, including no-shows. Based on this information, you are in violation of standard parole condition 1, release direction. You failed to admit to the App Foundation on 9/16/24 as deemed clinically appropriate to address your recent relapse on cocaine and fentanyl. On 9/13/24, you requested placement at the App Foundation and you were aware that you were accepted for admission as of 9/16/24. On 9/13/24, you left your parole-approved residence at the Connection Incorporated Eddy Center Halfway House, and on 9/17/24, you admitted to your parole officer that you had no intention of returning to the halfway house or entering the App Foundation. Based on this information, you are in violation of standard parole condition 1, release direction.
Charge 3, residence.
On 9/13/24, you left your parole-approved residence at the Connection Incorporated Eddy Center Halfway House without permission or notifying your parole officer. You did not return, and you did not make any attempts to communicate any issues or barriers of you continuing to reside in your parole-approved residence. You did not report any concerns to Eddy Center staff. On 9/17/24, you admitted to your parole officer that you left and did not plan to return to the halfway house. Based on this information, you are in violation of standard parole condition number 1, release direction.
Charge 4, absconder.
On 9/13/24, you left your parole-approved residence at the Connection Incorporated Eddy Center Halfway House without permission or notifying your parole officer. You did not return, and you did not make attempts to communicate any issues or barriers of you continuing to reside in your parole-approved residence. You did not report any concerns to Eddy Center staff. On 9/17/24, you admitted to your parole officer via phone that you left and did not plan to return to the halfway house. You further told your parole officer that you intended to run and keep on running. On 9/18/24, you were approached in the town of Vernon by 2 parole officers. Despite verbally acknowledging the parole officers, you kept on riding your bike away from parole staff and refused to stop when directed to do so. You intentionally evaded parole staff by entering a wooded area on your bike. Based on this information, you are in violation of standard parole condition 1, release direction.
Charge 5, drugs.
You admitted to using cocaine on or around 9/13/24. You rendered a urine toxicology which was positive for cocaine. You signed a voluntary admission form admitted to cocaine use. You requested admission to the App Foundation to address your recent relapse. On or around 9/23/24, Premier Biotech confirmed that your urine sample was positive for cocaine. On or around 9/13/24, you rendered a urine toxicology which was positive for fentanyl. On or around 9/23/24, the Premier Biotech lab provided a report which confirmed that your urine sample was positive for fentanyl.
Charge 6, behavioral management program.
You failed to attend the CHR Explore program on 7/15/24, 7/22/24, 7/29/24, and 8/5/24 per the provider. On 8/6/24, you were unsuccessfully discharged from the CHR Explore program due to violation of the attendance rules, including no-shows. Based on this information, you are in violation of additional condition of behavior management program for domestic violence.
And charge 7, halfway house placement.
On 5/30/24, you were found to be smoking and in possession of marijuana at the CPA Halfway House. On this date, CPA Halfway House staff smelled cigarette and marijuana smoke coming from your room. Upon entering, the smell got stronger. After searching your room, marijuana contraband was found in your closet. Based on this information, you are in violation of the Halfway House agreement. I may not use tobacco products within the Halfway House. I may only smoke in designated areas at designated times. I will not consume or possess marijuana in the Halfway House. On 9/13/24, you left your parole-approved residence at the Connection Incorporated Eddy Center Halfway House without permission or notifying your parole officer. You did not return, and you did not make any attempts to communicate any issues or barriers of you continuing to reside in your parole-approved residence. You did not report any concerns to Eddy Center staff. On 9/17/24, you admitted to your parole officer via phone that you left and did not plan to return to the Halfway House. Based on this information, you are in violation of your conditions of parole, specifically additional condition of Halfway House placement. You are also in violation of the Halfway House agreement. I will not leave the physical confines of the Halfway House unless authorized by program staff or parole.
The state has also filed the following exhibits, starting with Exhibit A, P.O. Walker.
I apologize. I don't have the list of exhibits in front of me.
Okay. Exhibit A, signed statement of understanding and agreement conditions of parole. Exhibit B, remand to custody order. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, halfway house agreement. Exhibit F, offender misconducts. Exhibit G, voluntary admission form. Exhibit H, premier biotech lab report. Exhibit I, incident report from the Eddy Center halfway house. Exhibit J, explore domestic violence program referral and discharge report. Exhibit K, residential substance abuse referral. Exhibit L, email from App Foundation admission. Exhibit M, State of Connecticut Board of Pardons and Paroles decision information summary. And Exhibit N, State of Connecticut Board of Pardons and Paroles revocation summaries. Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and at this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. P.O. Walker?
I have nothing further to add at this time. Thank you.
Thank you. It is now the defense opportunity to present evidence and speak to any of the evidence. Counsel?
Yes, thank you. Mike, I just have some global comments to make, and they are specifically in regards to charge 1, the second portion of charge 2, charge 3, charge 4, charge 5, and again, the second portion of charge, I apologize, not that, the second portion of charge 7. And my comments are just that if you look at the dates, when all of these things began to happen, it's approximately around the September 10th of 24 date, which coincides with my client suffering a relapse. And unfortunately, my client does live with addiction issues, and he's been living with those issues for some time. And obviously, incarceration is not the way to properly address those issues. But those are just my comments in relation to those portions of the charge. I think it's evident that having been released to parole supervision in April 29th of 24, and all of these things kind of happening around the same period of time, I think it's evident that these are all directly related to him relapsing. So those are just my comments in regards to the charges.
Thank you. P.O. Walker, anything further?
I just want to reiterate that he was offered APS placement based on his report that he did relapse and needed treatment. We did make several efforts to try to get him into treatment. He did not comply.
Thank you. Counsel?
No, I don't need to go back and forth. That's sufficient. Thank you.
Thank you. Regarding charge 1, reporting, I make a finding based on state's exhibits A, D, and F. Charge 2, program participation, I make a finding based on state's exhibits A, D, F, J, and L. Charge 3, residence, I make a finding based on state's exhibits A, D, E, and I. Charge 4, absconder, I make a finding based on state's exhibits A, D, and I. Charge 5, drugs, I make a finding based on state's exhibits A, D, F, G, and H. Charge 6, behavioral management, I make a finding based on state's exhibits A, D, F, and J. Charge 7, halfway house placement, I make a finding based on state's exhibits A, D, E, F, and I. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney, as well as the state, will have an opportunity to speak to your background and history. P.O. Walker, do you wish to make a statement regarding Mr. Dattilio's background and history?
I do not. Thank you.
Okay. And counsel, it is now your opportunity to speak to Mr. Dattilio's background and history.
Yes, thank you. My client is 37 years of age. He's single. He has no children. He was raised in Manchester, Connecticut, where he has support of his parents, both his mother and father, as well as a sister. While he was in the community under parole supervision, which was approximately 5.5, 6 months. During this time, he successfully completed Community Partners in Action halfway house program, which is located in Hartford. He was then able to self-sponsor to an apartment in Manchester, which was the first time he was ever able to do so and achieve this level of independence. I think it's unfortunate that that situation proved to be difficult for him as he suffered a relapse and found himself in this situation again. My client was able to obtain employment. He worked as a full-time painter, working with his father's company, also located in Manchester. He also assisted a friend in delivering groceries in order to make income. By way of treatment, he attended the Root Center for Advanced Recovery in Manchester, and he received medication-assisted treatment in the form of methadone while attending that programming. He also completed an IOP at Natchog Hospital River East Treatment Center. In addition, he completed approximately 7 sessions of the Explorer program. While he's been incarcerated over this, I believe, since his remand, which was November 4th, he has written to DOC staff attempting to obtain employment within the Department of Corrections, as well as he's participating in medication-assisted treatment, again, in the form of methadone, and he participates monthly in groups. His future plans would include being sponsored by his parents, who again are in Manchester, with employment opportunities, again, to include working with his father's painting company. Mr. Dattilio will complete his parole supervision in May, which is just around the corner. He has no other supervision to follow his parole sentence. His PO notes that he's at risk of overdose if he remains in the community. However, I'd submit that he's at greater risk of an overdose if he remains incarcerated and then re-enters the community with no structure or supervision to assist him in obtaining treatment. So it would be we would be asking that you re-parole him at a date prior to his end of sentence date that would allow him just enough time to enter back into the community with some structure in place so that he could receive treatment. I don't disagree that he's at a high risk. He does suffer from the illness of addiction, and he suffered from it for a very long time. But remaining incarcerated up until that point isn't going to do him any good. He certainly would have been a candidate not for the absconding charge to participate in the TOP program, and that could have been sufficient to help him transition back into the community. But certainly he needs some sort of help. And I understand that he did ask for treatment. The App Foundation was available to him, and that perhaps he did not avail himself of that opportunity. But unfortunately, I think when people are in the throes of addiction, they're not making the best choices. And I think it was a lot to say that he came initially to his parole officer and said, "I need help." And I think it would have been different had the help been available that day when he was asking for it. And it's hard when you tell somebody, okay, help will be available in 3 days, to think that they're going to do the right thing. So all I'm asking is that he's going to end his sentence on May 11th. We are just asking that he have some opportunity to go back into the community with some supervision so that he can have some treatment in place, and we can be setting him up for some level of success. Thank you.
Thank you. P.O. Walker?
I'm hesitant just based on the fact that I'm very familiar with Mr. Dattilio. I've supervised him at least on 4 different occasions. All 4 occasions he has relapsed. All 4 occasions I have had to either send him to the halfway house or remand him. One occasion I did bring him to APT and he did comply. My concern remains that while being supervised by parole, his anxiety is so high that it becomes a contributing factor to his relapse. I do not believe that him being supervised in the community on parole will be effective, and I do not believe that it will be helpful to him. I think him being released when he is no longer being supervised by parole would actually be better for his anxiety, which leads to his relapse. Thank you.
Thank you. Counsel?
And just, yeah, my last comment would be, he has very supportive parents who live in the community, who are good citizens. Father owns a company. I think, he has a place to go and live with his parents, but his parents also have, a limit as well. And so they want to see their son succeed, and they don't want him just coming home from DOC with nothing in place. And I think that they would appreciate him coming home with some structure as well, so that they can assist him in finding success. But to have him come home with nothing, I think is quite frankly a recipe for disaster, considering the circumstances. I know Mr. Dattilio as well, and and it's unfortunate that I have to say that I've represented him several times in the past, so I've come to know him quite well. And so I understand exactly what P.O. Walker is saying, but on the flip side of that, I think coming out with nothing is worse than coming out with something. That's it. Thank you.
And P.O. Walker, anything further?
Just that the department does have discharge planners which can assist with putting services in place upon his discharge. I think his parents are also not in a position to take him home. They have voiced that concern several times. That is how he ended up having the apartment on the last release ready for him, because they were not willing to sponsor him. And the only way they would support him in the community and allow him to work with them again was if he had that apartment, which is how they paid for it. That was, that was their doing. So yes, they'll support him, but he's not going to be able to reside with them. And he's not going to be able to work with his father.
Thank you. And counsel, you're all set?
I'm not good. Yeah. Thank you.
Thank you. I'm going to take a moment before I make my recommendations. Mr. Dattilio, this is your fourth violation, in addition to 2 top placements. Regarding this violation, you were supervised for about 4.5 months prior to absconding, and your whereabouts were unknown for approximately a month and a half. Taking all testimony today in consideration, as well as your history, I recommend revoke with no new re-parole date, which is an approximate 6-month sanction. In the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: no consumption of alcohol, domestic violence, no contact with victim DR, general no contact with ARC, halfway house placement, mental health evaluation, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 16th, 2025. So on January 16th, 2025, the board is going to take a look at your case. They can lessen my recommended sanction, or they can let my recommended sanction stand. But regardless of what, you'll receive written decisions from them within the week of January 16th. Okay. Counsel, anything further just to add?
No. Thank you. Thank you, P.O. Walker, and good luck, Zachary. I
Thank
wish
you,
the
Mrs.
best.
Jones. Thank
Yep.
you, Mrs. Jones. I appreciate you.
You're welcome.
Thank you.
Thank you.
Thank you.
You're all set, sir.
The door's locked.
Oh, okay.